Kocaker versus the state.
Good morning, Mr. Chief Justice, and may it please the court. My name is Chelsea Shirley, and I represent Mr. Kocaker. And Mr. Kocaker suffers from neurovascular lesions that have been increasing in size, number, and location, and which render him incompetent to proceed. These neurovascular lesions have been confirmed by neuroimaging and are essentially holes, or areas in Mr. Kocaker's brain where there should be active neurological tissue, but where there is none. And these holes are caused by a small vessel brain disease, which is getting worse over time and for which there is no cure. And as a result, multiple experts in this case have found Mr. Kocaker to be vacuous, impoverished, flat, and vacant in his demeanor. And distinct from this neurological condition, Mr. Kocaker also suffers from a chronic, serious mental illness. And taken together or separately, these conditions impair his ability to think logically, to logically or rationally understand the post-conviction process.
And the trial court considered all of the testimony that supports the statements that you're making, correct? It was all presented to the trial court?
Correct, Your Honor. All of this evidence was presented to the trial court.
And would you agree that there is competent and substantial evidence in the record to support the trial court's finding of competency?
I would not agree, Your Honor. And
there's no testimony?
There's not competent or substantial evidence, and there's two reasons for that, if I may.
Okay.
So the lower court found that Dr. Hurst and Dr. Suarez were the most credible experts in this case. And if you look at page 11 of the order, there are two reasons for that. The first is that they did a thorough review of the mental health records, and the second is that they had daily observations of Mr. Kocaker. And there's no evidence to support either one of those findings. And the first is that in this case...
Didn't they review the SFETC records? I think I have that acronym right.
Yes, Your Honor, you do.
And SFETC is a in-treatment hospital where Mr. Kocaker was located in South Florida, right?
Correct, Your Honor.
And those records indicated a daily observation of Mr. Kocaker, did they not?
Correct, Your Honor.
How's that not... I understand where you're getting at, which is that the doctor themselves did not daily observe, but they had information before them in Mr. Kocaker's time at the hospital from which there was daily observation from which they rendered their opinions. Isn't that correct?
That's correct, Your Honor. But this information was given to all of the experts. So the trial court signed a discovery order, and those daily treatment records were given to all 7 experts. It wasn't just Dr. Kirsch and Dr. Suarez that had this information.
Well, no, I understand that, but the statement is that they conducted a thorough review and had information regarding his daily time. They did, and yet they rendered an opinion that was contrary to the other doctors. Why is that not, as Justice Lawson said, competent substantial evidence to support the trial court's finding?
Sure. Well, just because these doctors had the same records available to all the other doctors doesn't inherently make them more credible. So he found them more credible because they had these records, but all 7 experts had these records.
Well, they were certainly on scene. I mean, one of the doctors even worked at the hospital, right?
Correct, but Dr. Suarez did not. He testified he was an independent contractor, and he only saw Mr. Kocaker one time. He didn't work at the treatment center. He saw him one time.
At least it's to the doctor that did. That statement would be true, and that doctor would be more credible, at least to the trial court judge who heard the testimony, than some of the other doctors, right?
Dr. Kirsch would be the doctor you're referring to.
Yes.
She did not see Mr. Kocaker every day. So what she testified to is she saw him one time on the day he was admitted. And on that day, Mr. Kocaker had no idea why he was there. He had no idea who sent him there, what he hoped to get out of the treatment. And this is important because Mr. Kocaker was present at the court hearing where the court said, I'm sentencing you to the treatment center, and here's why. And yet, a month later when he shows up, he has no recollection of that. He doesn't know why.
I'm certain there's evidence contrary to what the doctors testified to, just like there's evidence probably supporting their conclusions. But I guess my point is that there's a doctor who worked at the hospital who had records of his everyday treatment, who did render an opinion, and the trial court found that to be more credible. How is that? How could we, as an appellate court, overturn those findings based on that record?
A couple things. So again, she had access to the same records that everyone else did. And she testified she did not see Mr. Kocaker every day. She saw him about once a week, and it was her or someone else, and it was in person or in video. So again, that's a lot of ors in that statement. That's not seeing him every day and interacting with him. But also, the second, going back to Justice Lawson's question, the second reason the trial court found them the most credible is because they allegedly did a thorough review of his mental health records. And that's impossible because they did not have his Department of Correction records. And we're talking 3,000 pages of records, which document suicide attempts, catatonic states, stays in psychiatric wards, psychiatric observation units, swallowing razor blades, trying to hang himself, shooting himself. The Department of Corrections said he's psychotic, not otherwise specified, or he's major depressive disorder with recurrent psychotic features. 3,000 pages of medical records that they did not have. So the trial court's finding that they did a thorough review of the mental health records is simply incorrect.
What records did they have? They
had only the records they created at the treatment center.
And he was there for how long?
He was there about 2 months, maybe 3.
Right. And how many pages of records, with video observation and all of that, did that compile over those 2 months of observations?
I'm not sure off the top of my head.
Significant, right? You would agree?
Significant, but
Right.
Again, it was given to all of the experts. It wasn't Dr. Kirsch that only had access to this information.
I mean, he was incompetent in the past. That's why he was in the facility, to be restored to competency. Correct?
Correct, Your Honor.
Okay,
Yes.
so these were the doctors that were overseeing, the one was the doctor that was overseeing his treatment and evaluating him to determine whether it was successful in restoring him to competency, correct?
Yes, Your Honor, that's correct.
Okay. So I'm having a hard time understanding how it's particularly relevant to that expert's opinion. I mean, he knew that the defendant was incompetent in the past, had the severe psychological problems that you mentioned. That's why he was there.
Yes, but I would disagree that she knew to the extent. And I say this because in addition to not having those 3,000 pages of mental health records, she also didn't have his prior neuropsychological testing. And she testified to this in her testimony because when she was asked by collateral counsel, well, why can't you correlate these neurological lesions with his scattering test score and his low test scores? And she said, I don't know the history of his scores. All I know is he scored these things in 2016. And so without having the history in the DOC records, without having the prior neuropsychological testing, without knowing what the prior doctor said about his atypical behavior.
Why would the scores matter if everyone agrees he's not malingering? In other words, there's no reason to doubt the scores. In a malingering situation, I can see how that might be maybe more relevant. But where everyone agrees he's not malingering and all the doctors relying on tests, why is it relevant what he tested previously if now, after having been restored and received the treatment there, that his scores are now in line with someone who's competent?
I agree with you, Justice Luck. There's no evidence to say he's malingering, but Dr. Suarez and Dr. Kirsch said they had to give credence to the fact that he was malingering and found that the MMPI scores, for example, showed malingering and that his low scores were not giving good effort. And this is because they didn't know the history of the scores, which tie back to the lesions. So Dr. Suarez, Dr. Kirsch, all of the other doctors, Carpenter, Burstyn, Mayer, Eisenstein, they all said these scores are atypical. And these scores represent someone with dysfunction. So the other 4 doctors said that dysfunction correlates with the brain lesions, and we know because we can compare it to the 2007 scores. Dr. Kirsch and Dr. Suarez didn't have the prior neuropsych scores, so they couldn't see that his scores are dropping as we're seeing an increase in lesions and as we're seeing more scatter in the test score to correspond with areas of the brain that have more lesions and larger lesions. So they said these atypical scores must be due to him giving not good effort.
Can I ask, what are we supposed to, so we have these precedents saying that at the end of the day, the expert reports are just advisory and that it's ultimately the trial judge's responsibility to determine competence. And in this case, the judge himself looked at the videos of the interviews, et cetera, and you obviously have seen what he said about that in the order. So what are we supposed to do with that?
Well, just because the trial court makes these findings doesn't make them immune. So this court can overturn them if it doesn't find competent and substantial evidence to support them. And so I think by relying on doctors that had the least amount of information of Mr. Kocaker, they didn't have his prior history scores, they weren't familiar with all of these things, that making them more credible simply because they work for the treatment center or because they allegedly had the same access to everyone else doesn't inherently make them more credible. So there's no substantial evidence to say they're more credible because they had the same information everyone else did.
But counsel, what Justice MUNIZ is asking, and I don't want to speak for him, but what I hear him asking is, despite what the doctors have said, so even putting it aside, our case law has suggested that it's an independent obligation of the judge, whatever the doctors say, not just to parrot the doctors, but to make their own determination based on observations and other evidence in the case. The trial judge here looked at the videos himself and rendered, or herself, and rendered an opinion here based on that observation of the evidence. How is that not alone competent and substantial to support the findings of the trial court? I think that's what I understood Justice MUNIZ to be asking.
I apologize, Your Honor. So I think because the videos reflect what the experts testified to. And there was no finding in the lower court's order that there was more evidence he saw in the video to corroborate or that didn't come out at the evidentiary hearing. So with the record that we have, this court has the same amount of information the trial court did. And the trial court's findings can still be reviewed for an abuse of discretion, which is what we have here. So we have the court relying on these experts in the first round of competency proceedings, Dr. Mayer, Dr. Burson, Dr. Carpenter, and finding them the most credible, and then 6 months later, completely disregarding Dr. Mayer's finding no credibility findings with him at all, and then saying, well, I'm going to rely on these other doctors that have actually seen him a less amount of time and have less information, even though I think these other experts were the most credible the first time around. Like, that is just illogical.
And how about I understand, I guess your argument on it, the rule assumes that there are some types of claims where you don't really need the defendant's help, and then there are others where you might. And I understand sort of the argument that, well, if someone is incompetent, how do I know of the things that they might point out to me if they were? But what are this, in this case, it hasn't ever really been clear what the specific issues are that you would want to be able, that you would want his help with. Or, there's never been a clear, I know that in the rule, it sort of has this notion that the trial judge is supposed to be able to very specifically say, look into his competence so that, the defendant can help with X, Y, and Z issues, and then afterward. But that here it was more sort of fuzzy. It was just kind of look into the competence, and then you guys, amended the motion and everything. So what are the issues that are even relevant? What are the issues that you feel like you haven't been able to develop because of the competence issue?
The main issue, I believe, Your Honor, is the ineffective assistance of trial counsel. So that does require factual development. The case law is very clear. In order to properly investigate that claim, in order to properly present it, we have to be able to talk to the client. We have to talk to the client about the things he discussed with trial counsel. Did you tell him to investigate this, and did trial counsel actually do it? Are there things that you asked trial counsel to do that he never did? Mr. Kocaker, for example, can't even remember that he testified at his capital trial. So we can't talk to him about, well, how did trial counsel prep you? What did they talk to you about? And I understand that I could ask trial counsel these questions, but part of the inquiry is what did the defendant actually understand?
So, but that's an issue in every one of these cases, right? I mean, so I guess maybe it would only, if it's a successive thing, I mean, do you think the rule is based on a false premise that there are going to be cases where someone could be not competent, but the 3851 proceeding would still be able to go forward?
I don't think so, Your Honor. I mean, there's things about a capital defendant that only the capital defendant knows. And granted, a lot of it would be penalty phase, which we do have Hurst relief in this case, but a lot of it also goes to guilt phase. Like, talk to me about what you did the days leading up to the crime. Where did you go? Who did you see? Talk to me about the day of the crime. Do you have an alibi witness? Talk to me about, your intoxication levels or things like that. Talk to me about what happened immediately following the crime. Who do we need to talk to about your movements? He can't help with any of these things because he doesn't have a memory of them. And so in order to fully investigate a guilt phase claim, we have to be able to talk to guilt phase witnesses, which we can't do because Mr. Kocaker doesn't remember them.
Well, and on that issue, though, it seemed like both some of the experts and the trial court itself commented on the fact that he did seem to have a lot of recall of the events. You know, obviously he's saying something different than what the jury found, but you know, that's one where there was an observation of his ability to talk about the day in question and all that.
Yes, Your Honor, you're correct. The lower court did find that. However, as Dr. Mayer testified, it was just a rote, routine memory. Like Dr. Mayer gave the example that when you have a dementia patient, they can tell you the story from 15 years ago of when they went fishing, but how many of the facts in the story are actually true or what it means to the present day, they can't tell you. And so this story that he can repeat is a sign of dementia. And Dr. Mayer, it was very important in this regard because he was the only expert who worked with dementia patients. He has a clinical practice. He doesn't only do forensics. And so in this practice, he works with dementia patients. He's familiar with the signs and symptoms when he comes across them. And talking to Mr. Kocaker, he says the story that he repeats about the trial is like a dementia patient and how he can't add to the facts. If you ask him anything other than those 5 facts he remembers about the day of the crime, he can't recall them. He has no memory. You ask him, who's this witness? I don't know. I've never heard of her name. Well, she testified at your trial. No, she didn't. I mean, there's no memory. So does that fully answer your question? Okay. And I say that I'm in my rebuttal time, so I'll reserve the rest. May it please the court. Good morning, Your Honors. My name is CHRISTINA PACHECO, and I represent the state of Florida in this case. Competent substantial evidence certainly does support the lower court's competency ruling. One element that was completely missing from Ms. Shirley's argument was Dr. Gamache. The lower court found Dr. Gamache, along with Dr. Suarez and Dr. Kirsch, more credible than the other experts. Dr. Gamache had been a longtime expert in this case, having evaluated defendant all the way back from 2008 during the penalty phase. He had all the DOC records. He had all of the other experts' records, and he consistently refuted the other experts and found that there was no evidence of any sort of neurocognitive disorder or psychosis or anything like that. And then when the defendant went to the South Florida Treatment and Evaluation Center, that's when Dr. Kirsch came in, and she is the head of that entire treatment center. She evaluated him and could not find anything that she could even diagnose or treat him with there. She then had Dr. Suarez conduct extensive neurocognitive testing, and he's an independent doctor. He did a battery of very extensive tests and found, again, no evidence of anything that the experts previously that had found him incompetent found no evidence of that in the testing at all. And so the lower court relied on these 3 experts. There's extensive findings by the lower court that support the lower court's ultimate ruling, and respectfully, we're not here to reweigh the credibility of the witnesses. That is a function of the trial court. The trial court did that. There's evidence for why the trial court found these 3 experts more credible, and there's opposing counsel doesn't agree with that and wants this court to look at the other experts, but that really isn't the function of this court on appeal. With regard to, Justice, your question regarding what claims required Mr. Kocaker's input, I think it's telling that in the reply brief, actually, counsel conceded that none of the issues that were brought before the court in the post-conviction motion actually required Kocaker's input, and they were all legal issues. There's not been any claim raised that counsel stated required further input from him. And also, it's significant in the record that back when after the initial pre-trial competency hearing where Kocaker was found competent, his trial attorney at that point said, "We have never had any problems with our client. He's very helpful, he's very talkative, he gives us a lot of information." And that's in volume 24 and page 23 of the record. So there's been no claims that even require his input that have not been, he hasn't been able to provide. And the evidence is clear that he had no problem talking with his attorneys pre-trial and during the trial. And I would also like to point out that the trial court in this case that found him competent, that is the ruling at issue here, has been the same court all along. So that judge saw Mr. Kocaker testify during trial, during penalty phase. He testified relevantly. He was able to respond appropriately to questions. And then during the competency proceedings, the judge also did look at the evaluations, the video recordings of the evaluations, and could see how Kocaker behaved then. So the judge was in a great position, the perfect position, to be able to assess these witnesses, and did so. And there's competent, substantial evidence that supports that ruling, and absolutely no basis to disturb that ruling.
How are we, just from a kind of technical perspective of how we're doing our review, what standard should we be applying when we're talking about looking at the judge's kind of ultimate determination? Because some of our cases talk about abuse of discretion, some talk about competent substantial. It's not obvious how you apply the competent substantial when you're talking about the judge's own kind of observations. Do you have any thoughts on how we should be thinking about that?
Yes, Your Honor. I agree that the case law is a little confusing with kind of interchanging the abuse of discretion and the competent substantial evidence standard. But the case law is clear when we are looking at a trial court's credibility determinations between different experts. That ruling is reviewed for competent substantial evidence, and that's what we have here. The court is finding certain experts more credible and relying on those experts' opinions over others. So the appropriate standard for this court to apply would be the competent substantial evidence standard. If there are no further questions, I will rely on our briefing for the remaining time and ask that the court affirm the lower court's denial of relief. Thank you. Thank you. Just very briefly, Your Honors, as far as Dr. Genghis, the state said that he did have access to the Department of Correction records, and that's partially true. So the state cherry-picked 500 pages out of the 3,000 to give to Dr. Genghis for his review. So he did not have the vast majority of the records here, and you can find that in the original record on appeal. So again, 500 out of the 3,000. The second thing is that Dr. Genghis had an outlying opinion on many things that no other expert agreed with, and he also gave Mr. Kocaker a test that he made up. He said, "I made up this 20-question test and gave it to Mr. Kocaker. It's not normed or standardized. I'm not even sure how it passed Daubert or Fry to come in, but this is what he relied on for his opinion." And the second thing is that just because the trial court found Mr. Kocaker competent pre-trial does not mean he is currently incompetent. The case law is very clear that you have to do a competency evaluation and that someone can be competent and then incompetent and then competent. It can vacillate and waver. And so part of the reason the trial court found Dr. Carpenter the most credible expert the first time around is because he saw Mr. Kocaker pre-trial and he gave him a, quote, marginal pass in competency, and then he saw him in post-conviction and he said he does not make it across the threshold. He has declined drastically. It looks like he's aged 20 years and 5. There are more lesions on his brain. He's more vacuous. He's more vacant. Something is happening to this man. And because of that, the trial court found him, or excuse me, the lower court found him more credible during the first round of post-conviction competency hearings. And so that unique perspective should have carried over. And the lower court gave no reason why now the expert he found most credible through 2 of the 3 rounds of competency proceedings, he's going to completely disregard this expert's point of view. And with that, unless there's any other questions, I would ask this court to reverse because Mr. Kocaker is fragile and confused and incompetent. This rendered the post-conviction proceedings below fundamentally flawed. And for that reason, we would ask this court to reverse the lower court's judgment. Thank you.
Well, we thank you both for